Good afternoon, everyone. Welcome to another episode of Cannabis Live with Cannabis Legal Group. My name is Nicholas Galendez.
And mine is Jennifer Domain.
We're here to talk to you during a very exciting but potentially scary time in Michigan's medical and adult use marijuana market. Episode 73, we're going to be talking about shocking threats to Michigan's marijuana market. We also have a few updates related to the Medical Facilities Licensing Act, rules promulgated by LARA, some policy positions that they're going to be taking. We're also going to be talking about THC limits that they recently updated for the medical program. So there's certainly a lot of things that happened during this last quarter of the year as we kind of wind down to the holidays and into 2019. So there's definitely a lot to go over. Bear with us. We definitely appreciate you liking and sharing this information. I know a lot of people out there are concerned, especially about these changes we're going to be talking about to both the, to Prop 1 most importantly, but also, there's questions about the changes that are proposed to the Facility Licensing Act. And, we're happy to be here as a resource for you. Like us, share us on Facebook, and we really appreciate you watching, and feel free to ask any questions as we go along.
So I think one of the first things that we'll get started with is on a happier note. Yep. We have Legalization Day, which is now December 6th. So on this past Monday, the Board of Canvassers certified the election results and decided that yes, the results are accurate. And so 10 days after that date, the law goes into effect, which is December 6th. So on December 6th, it is now legal to possess, consume, and cultivate pursuant to the terms in the new law. And for right now, that remains the same, but we'll get to the changes that might be coming up in a little bit. So stay tuned.
Yeah, and as we have been telling everyone from Election Day on, just because it passed didn't mean that you could smoke, you could grow in your house. You certainly can't smoke in public and drive around with it. But after the Board of Canvassers did certify that election data, 10 days after that date is December 6th, and that will be Legalization Day in Michigan. Kind of to switch gears from, I guess we're going from happy to less happy this episode, but we have a few updates for the MMFLA facility licensing framework, new rule sets. I guess first off, the Medical Licensing Board did announce that it is going to be meeting again for the second time in December, on December 21st. So in addition to the meeting that was already scheduled for December 7th, there will be another opportunity for licenses to be decided on and the board to deliberate. So that's an exciting news just to see them add another date before the end of the year, certainly to kind of get things advanced a little more further than things already have been.
Absolutely. I think a big reason for this is because the state's been seeing so much pushback and concern that they're not licensing enough businesses quickly enough to support the patients right now throughout the state. And so we're seeing this tension between the patients, the department, and the licensing board, and things are getting bottlenecked. And so without the board having more meetings to say yay or nay on licenses, our hands are really tied. So it's really, really a big deal for the state to have, or for the board to have another meeting. And I think that's the primary reason for that. Mm-hmm. But good news regardless.
Yeah. And also, in conjunction with that, again, kind of as the week unfolded, there have been more and more things kind of piling up as far as changes. These were a little more anticipated. The Joint Committee on Administrative Rules had been, already had a notice and comment period for the permanent administrative rules concerning the Facilities Licensing Act. After that notice and comment period, they met, and as of this week, they did approve the permanent rule set, which is now in effect for all licensed facilities and for the Facility Licensing Act. What we've really, we've looked through the law or the new rules, and we've, haven't noticed too many substantive changes, but I think the one that was on most people's minds was home delivery for provisioning centers. That was included, but there were a few changes. So Jennifer, if you want to kind of go over those, definitely kind of worth going over in terms of how those affect provisioning center licensees.
Absolutely. So the the proposed permanent rules had a provision for home delivery where provisioning centers could have an individual work for them and serve as a driver, and they could deliver packages or items to patients, and they could do up to 3 deliveries per trip. So they would have to input the route that they're using, the names of the people that they're dropping things off to, basically like a manifest, and send that to the state for the state's regulation. But when the permanent rules, sorry, I'm getting proposed and permanent kind of tied on my tongue. With the permanent rules, they switched it around to where now more than one employee could serve as a driver, and the number of deliveries has been increased from 3 to 10. So I think that makes things a lot easier, especially when we're going to have a lot of people probably taking them up on this delivery option. And rather than constantly running back and forth from the business to 3 locations, now they can just take a whole set of deliveries and knock out 10 at one time.
Mm. And definitely, I think there's going to be a lot of structure here. The plan for delivery needs to be approved by LARA. The cars will have GPS in them. They can carry no more than what the patient orders, which is up to 2.5 ounces a day. And those also have to be within the monthly purchasing limits too. In addition to that, the packaging of the products will have to be, per order. So it's not going to be one big bag that the person grabs and gets, and maybe there's mistakes there. They're going to have to be kind of separately cordoned off and really organized in a very neat fashion. LARA is going to promulgate rules about how much money can be held at a certain time for these delivery drivers. But I think the fact of the matter is that I think what were the numbers? 108 municipalities had opted in. And so that creates a big issue with patient access, never mind all of the other stuff that's going on with patient access for medical marijuana. But this avenue allows those provisioning centers to, change their business plans to better serve these patients by offering a delivery option to them. And I know you can see this in a lot of other states, and California has a pretty robust delivery system because same kind of issue. Certain population centers aren't opting in. There's a lot of trouble with people being able to get to these storefronts and get their medicine in Michigan's case, or in California they have a mixture of adult use and medical. So a little different there, but I think it's a good step forward that LARA, listened to notice and comments, tweak their rules a little bit to allow for more of these deliveries as well, because to have 3 people that you can only deliver during one trip definitely kind of strains your resources, and certainly only having 1 employee do that. So now you can have multiple employees, presumably, if LARA okays that plan, and you can deliver up to 10 places per trip. So that's significantly, opens up the gates a little bit.
And another feature that is really nice is it also continues to allow for online orders. In theory, you can have a secure website that authenticates your medical marijuana card, and you can place an order online. So if you can't make it to the actual provisioning center, the brick and mortar store, then at least you can order through them online and then have it delivered. But Nick, what's your take on, can we have like an Amazon now where you don't even really have a storefront, but you can just order online and have it delivered to your door? Is that something that we can do?
And no, I think that's completely prohibited by the framework of the law and the rules. You need to have an established licensed facility before you can kind of put yourself out there to do home deliveries. So kind of similar situation with how, for example, adult use, you could potentially give away things, but you can't be selling them and getting money for that back. I think that's a similar situation. In order to be able to take advantage of this particular thing that the law allows you to do, you need to be a licensed facility. You need to have all of your plans examined by LARA. You need to be held under compliance, strict compliance in certain aspects, in order to be allowed to have this privilege of delivering to patients throughout the area that you're located in as a provisioning center.
I completely agree. Why don't we talk a little bit about the new THC limits for the products? I think that's a huge thing that just came out right now. So there was a prior rule in place that said that if you were selling an edible or creating an edible, the maximum THC content per serving was 50 milligrams, and the maximum THC in a container would be 500 milligrams. But that got reduced in this new rule that came out, and the THC per serving is still 50 milligrams, but it reduces the overall THC in the container from 500 milligrams to 200 milligrams. What's your take on that?
I can see where they're coming from, but I don't agree with, why or what the actual amount is. I think at a minimum, 50 milligrams, 500 milligrams in a serving was more than enough. But even in some cases, it makes it kind of impractical for people with chronic and debilitating conditions. If they're used to buying 1,000 milligram, candy or chocolate from a provisioning center, and they all of a sudden need to buy 2 of those to get the same effect for their condition and their medication, then that obviously creates a problem. Instead of quality over quantity, it's going to be quantity, and in certain situations, it makes it a little bit more prohibitive for those particular patients to, instead of eating 1 brownie, they now have to eat 5, and the brownies are the same size, but you take the dosage out of that and then you turn it into can somebody eat 5 brownies in one sitting, just to get their medicine through that delivery method. And I think it's a little bit arbitrary to have reduced it that much in milligrams, and I really hope that there's a lot of feedback negatively towards this, just to be able to open up it to those who do need this type of medicine the most. If you have lung cancer and you've been having a certain dosage of an edible, and now you have to have 5 times that dose, it just doesn't make sense to me. So similarly to what we'll be talking soon for patient access, I think for patient practicality, for patient being logical about what our limits are and why, I think is something we need to be very careful about, and make sure that the agencies making these rules really know about that and hear about that, so they can make an informed decision about it instead of throwing a number out there and hoping it sticks.
But, the agency actually, I think, has become a little bit more cognizant of patients' needs, and so I'm hoping that not only will they listen to input and comment regarding the dosages, but they're now proactively making a suggestion to the board that they should allow licensed facilities to obtain marijuana from caregivers in addition to licensed grows to supply these facilities until January 1st, until the end of the year. And I think that's a big, big step right now by the state that will show that they're supporting the Michigan patients, and they're really doing what it takes to make sure that there's enough product to keep the patients supplied. But can you tell us a little bit more about that?
Yeah, so there was a breaking news bulletin issued by Laura. I think it was Wednesday or so. Again, there were a lot of things going on this week, so hard to keep track of when they exactly happened within this week, but all of them did occur this week. They basically said, and kind of follow me here, Laura intends at its December 7th meeting to make a recommendation to the licensing board that the licensing board not take disciplinary action against a licensed facility for taking caregiver product in up until December 31st if they follow a certain set of rules. So what this doesn't mean is that it was ever lawful to do so, that it could not be subject to license denial for those reasons. There's a lot of things, if you read between the lines of what this says, it's more important about what it doesn't say. I think that, so on the one hand, you have, yes, the temporary operation deadline is, going to be extended. It's going to be allowed to occur for a little bit longer, and the state is urging the board to allow for this alternative method of sourcing product from those caregivers who are under the Michigan Medical Marijuana Act. But I still just wish that, I want them to flesh this out a little bit more, because it is confusing at a first glance that people are going to see this and say, oh, I'm a caregiver, I can go ahead and sell this and it's fine. Or I'm a licensed facility or a temporary operator and I can bring this in and that's fine. And while it very well might be in the end, all this proposal or recommendation means is that the board, if they do, actually adopt this recommendation that Laura gives them, all that means is that they will not discipline an applicant who is before them for taking in caregiver product, as long as those rules are followed. So there's a lot of things that could slip through the cracks there. They're still, as we know, looking for things that happened years and years ago anyway. So all of that stuff is still fair game for a reason for denial, or even, maybe it gets past them on a reason for approval. But it doesn't mean it's not a free pass to run wild with this thing. It's definitely, I would still recommend to stay as cautious as possible. I don't know if you think any differently or.
No, I think that it's important to remember that this is just a recommendation to the board and nothing more than that. So and it's not even been recommended yet. It's not going to be recommended formally until December 7th. So if there's temporary operators out there watching this or licensed facilities, I would not do this yet until we get the thumbs up from the board or some sort of more definitive statement from the state. But if you're going to do this, then you're going to want to make sure that you get a signed patient consent form with their acknowledgement that this product was not tested. You're going to want to make sure that you input all of that information into Metric as soon as you get it. So that's until December 31st. And then after December 1st, we go back to the way things were. Everything has to be from a licensed facility, a licensed grower, licensed processor, and you can still sell that product that you had obtained from caregivers prior to December 31st. You don't have to get rid of it. You can still sell it, but you still have to have them sign that authorization form that they understand it hasn't been tested. So I think that those are best rules for you to follow if you're going to do this, but my feeling is that we should just avoid any discussion about that until we get a more definitive answer from the state.
Mm-hmm. And I'm sure we'll keep you updated after the board meeting, once there's deliberation, once Laura makes this recommendation, and once there's a vote on whether or not they're going to adopt this resolution to not penalize certain facilities for doing this. So stay tuned, certainly, and we'll kind of keep you up to date on that. Kind of transitioning now into the, we talked about legalization day, we talked about the rules and things affecting the Medical Marijuana Facilities Licensing Act and things that are kind of, evolving very recently. Now we're going to kind of talk about first, two sets of bills. One was introduced by the Senate, the other by the House. Right now we're in a lame duck session, meaning that they're all, they're going to be experiencing a change come to January. And this is kind of a last-ditch effort to get some legislation passed. Typically, during a lame duck session, the name speaks for itself. They're not really expected to do much because they're about, out of office, and it's hard to agree when you're about to go on vacation and you're about to, maybe some of them are no longer going to be in the House or the Senate anymore. So two of them were introduced. One affected the MMFLA, and the other one affected Proposition 1, the Michigan Regulation and Taxation of Marijuana Act, which we're going to leave for the end. So I think, just kind of easily transition along, we talked about the changes to the MMFLA rules. Let's talk about what some of these proposed changes in the House bill would have on the MMFLA, whether they're good or bad, and just kind of tell us a little bit about that.
Okay, absolutely. So this is House Bill 6500, and it's pretty lengthy. I took a few chances to look at it over the last 24 hours, and honestly, I really like it. I think that this House bill fixes a lot of the big issues we've been seeing for applicants when they're applying for their MMFLA facility license. First and most noticeably, I think it eases up on the definition of an applicant. So before, you had to provide supplemental applications for all the owners, the directors, the officers, anybody with a direct or indirect interest in this business. So that, plus their spouses, everybody's spouses. So that is really like all-encompassing for a lot of people, and that can make this extremely burdensome on not only the state to review, but also on the applicants. And so under this new House bill, they really kind of narrowed the scope of who an applicant is, and they've redefined it to make it much more narrow. So now it's just the owners and spouses, or it's just going to be, sometimes it's like the directors. It depends on the business entity type. So that's really nice. So if you know what sort of business entity you have and you're about to do this application, if this bill passes, that can really kind of narrow down who all has to do supplemental applications, which is really nice. Another interesting feature is that if your facility is capable of just using metric without the need for a third-party integrator, then you're allowed to do that. So there used to be a rule saying that you had to use a third-party software system to interface with metric, and now the state's saying, listen, if you want to just use metric and you're capable to do that, then go ahead and do that. We're not going to stop you. So that's pretty interesting. And it requires disclosure of names and addresses for shareholders of public corporations holding 5% or more ownership interest. This is different than before. They actually have a number on it right now. Not sure how I feel about that, but that's something that we're working through.
Well, so let's briefly kind of go over why that change potentially was made. So under the MMFLA as it exists right now, it requires the names and addresses of anybody with a 1% or more beneficial interest in the license holder. What that effectively means is that any shareholder above 1% would have to be vetted. And the issue with that is obviously that those are unknowable. There are certain threshold disclosure requirements in both the United States SEC rules and also in Canada that have different thresholds. And so what happens is that the state application process was more or less making it impossible for certain individual groups, certain structures of entities to actually apply and get their application vetted and looked at.
Right, absolutely. And so now with this 5% threshold, that kind of eases the burden a little bit for some of these entities, and some it doesn't really help at all yet. So that's something that we're kind of looking at, we're trying to figure out. But it's definitely a big change and something that should be noted. It also, and this is huge, is it relaxes the disclosure requirements for your criminal history. So as you guys might recall, we've talked about this over and over. If you don't disclose any arrest, any indictment, any charge, if you've been convicted, if you pled guilty, no contest, even if something was expunged or dismissed, it doesn't matter. You have got to provide that to the state or they will deny you for failure to disclose. Now, you only have to, under this new bill, if it's passed, you only have to disclose if you received a conviction or if you pled guilty or not, no contest, or if you forfeited bail. So that means that if you were arrested and you were released a few hours later, you don't have to disclose that. If you had something expunged, you don't have to disclose that. That is a beautiful thing. And I think that that's really going to make things easier because that's one of the biggest reasons we've been seeing for people getting denied right now. What's your thoughts on that?
Yeah, I mean, I think that by really pinpointing the reasoning behind the criminal disclosure requirements and also eliminating some of these different categories, like have I been charged with, have I been arrested with, it's very difficult for some people to remember when they got charged with something because normally, you don't see that happening. Something isn't very concrete and real to you until it actually, becomes down to that, conviction or that guilty plea. I apologize, we're having a few technical difficulties. We may need to take a quick break to fix them.
The audio is coming through. It's just the video.
Oh. Wonderful. Okay, well then we'll keep going.
It's a podcast now.
Yeah.
All right.
So we can kind of keep going on with that just to kind of wrap things up. But
there's also some other things that are new, or it reduces some of the requirements. You don't have to talk about bankruptcy disclosures anymore. There's no more bankruptcies. that need to be disclosed. You don't need to provide passport quality photos, which is something that's small, but it was a requirement, and it's kind of nice that you don't have to deal with that now. And it reduces the number of individuals that are required to be fingerprinted. So some of you might still have to get fingerprinted depending on your status with the application, but for some of the like the managerial employees, they wouldn't have to get fingerprinted anymore, and that's really nice. They also list out penalties for individuals or facilities who are holding themselves out as having a valid medical marijuana facility license, which I think is really interesting. That's something that we didn't see before, and I had always kind of questioned that, like what happens to some of the bad actors that are going to say, yeah, I'm totally licensed, like you should buy from me, So I think that that's something that we're going to definitely see passed in this bill. There's, I know, a fine, and it's $10,000 to $25,000 for a first-time violator. So if you're doing a first-time violation, it's a fine of no less than $10,000 and no more than $25,000. And you could be sent to jail for up to 93 days. If it's your second or subsequent conviction, same amount for the fine, but your jail time could be up to a year. And if there's serious injury or death, then you could go to jail, or prison rather, for up to 4 years. So that's significant. And then the last thing that I want to talk about this House bill that's huge, and I think a lot of you are going to be really interested in this, is it allows for more freely transferable licenses. So you can actually transfer your license a little bit easier than what was previously written in the law. The licensee is no longer like the exclusive person or entity for the license. So if you have the license in your company's name and then you change, perhaps somebody joins the business or leaves the business, the actual license remains with you and you can transfer that a little bit easier, and that's awesome. We're going to have to work out the kinks on this one, especially if it passes, but it's going to be a very, very exciting new opportunity here.
And just like we're going to have to work out the kinks with that, I do want to stop for a few moments so we can get our video feed back up online, because the next topic we're going to be talking about is very important, and I want to be able to have our video on while we talk about it as well. So please bear with us. We're going to come back on live in just a few moments after we fix our video feed.
Welcome back. Hope not too many of you left us during our brief intermission there. We have hopefully resolved all of our technical difficulties. So I think we left off just kind of addressing the House bill that affects the MMFLA. And in the Senate now, there's a new bill that is going to affect the new MRTMA, which is the adult use bill. So Nick, you want to talk a little bit about that?
And just to kind of back up for a second, I mean, both the one that Jennifer talked in depth about, touching the MMFLA, and this one, both have to go through the different governmental procedures. Both of them have to go through the House and Senate and be reconciled. The one that Jennifer was talking about does not need a supermajority. The one that I'm going to be talking about does need a supermajority of both houses and the governor's signature to be enacted into law. So when we're talking about these bills, they're not law, they're not gospel right now. They could be, and the House and the Senate only have a very short period of time to be able to do that, but it's still very concerning and troubling to me concerning this right here, Senate Bill 1243. What it basically does is takes what the people of Michigan voted more than 50% for and enacted into law that was going to become effective on December 6th to possess, consume, and cultivate, and completely guts it. The new proposed law eliminates a lot of the good things that were passed by through the will of the voters. They're very well within their rights to adopt. And it's something that I think is basically amounts to sabotage by the legislature if they do end up, in fact, passing this into law. One of the biggest things I think that people are going to be concerned about with this change to the adult use law, if it does pass, is that it removes your ability to grow 12 plants per residence. So despite the people of Michigan voting for allowing 12 plants in your residence, the legislature would like to pull the rug up from under you and prohibit you from doing that in your own home, 12 plants per residence.
And to be clear, that's not just them reducing the number of plants or tweaking what sorts of plants, that's taking away all plants. No plants can be grown at home. So that's a huge, huge change. And I think that we're going to see a lot of pushback on that because that was a huge part of the MRTMA.
Mm-hmm. The other thing, and it keeps getting better, another thing that this proposed Senate bill would do is eliminate micro businesses. So for all Michigan residents, this would have been available to you under the current law as it exists right now. One of the more appealing license types for smaller businesses, for locals, was the micro business license, where you could grow 150 plants, process it, and sell it from your retail store. And it actually prohibited, maybe you want to call it, big marijuana, from buying a bunch of micro businesses. It solely confined it to one license, and you wouldn't be able to sell it to anybody else. That is completely gone from this proposed bill. They want to completely eliminate that. They want to completely eliminate your ability to grow 12 plants and your ability to have any skin in the game for the adult use market with your own little niche craft cannabis store. They want to take that out completely.
So do you think that it's to encourage the larger marijuana businesses to come into the state, or do you think it's because they want it to look substantially identical to the MMFLA as it stands right now?
I will say that in the Senate bill, there were some fixes, I guess from a legal side, that, kind of harmonize them, that say what's exempt, say what appeal rights, they were kind of adding more flesh onto the skeleton of the proposal that was passed. But doing that is different than taking it, completely turning it upside down, ripping it apart, and putting it in a blender, which is more or less what this proposal, to me, feels like. Again, taking away your right to grow 12 plants, taking away your ability as a Michigan resident, if you're a smaller business owner, to grow 150 plants under a micro business. They also kind of fumbled with the numbers. The people of Michigan voted to allow a Class C adult use grower to grow 2,000 plants. I see what they did here. They took the A, B, and C under the MMFLA and superimposed it onto Prop 1, but they reduced that availability to grow that many plants by 500. Again, against the will of the majority of the people. And so as their constituents, you have to ask, why is this being done? Especially in those communities and those precincts that voted, favorably or overwhelmingly favorably for Proposition 1.
Absolutely. And to be clear, just so that we actually have the numbers out, it's reduced from 2,000 plants for Class C down to 1,500 Class C. So Nick and I, we've been questioning all day, why would they do this? Why are they trying to make this pretty much identical to the Medical Marijuana Facility Licensing Act when the people very clearly said that they would like to have more? So that's something there. I think that also one of the biggest additions that I have a problem with and makes it almost identical to the MMFLA, in my opinion, is they're adding a board. So under the MMFLA, we have the board, they say yea or nay, and they were appointed by an elected official, a political influence, and this adult use law very clearly gets away with the board. There's no board, and so you're issued licenses directly by the department. But now under the Senate bill, they're adding a board, and so now you have to go through the hoops with the department, then you have to wait for your turn to go in front of the board, and then the board has their preference on whether or not to issue you a license or not, And so I think that that's another huge hurdle. I mean, right now we're facing such a bottleneck because of the board. And, this is something that I don't think is very efficient at all, but we're seeing proposed in the new Senate bill. And so that's something that we're definitely going to have to fight against, in my opinion. But, if it happens, we'll have to deal with it.
Mm-hmm. And I think this is a good point, too, to discuss, the changes that she talked about for the MMFLA. All of the positives that have to go along with that are not in the Senate bill dealing with the adult use law. So basically, they took the old version of the MMFLA, copied and pasted the bad parts of it, put it into this new proposed Senate bill, and they want that to pass, and also eliminated everything probably as to why people voted favorably for this law. And so you can see a situation where if the House bill passes and all of the positive changes occur with the MMFLA, and the Senate bill passes containing the old version with all the bad rules in it from the MMFLA onto adult use, and the language doesn't match, right. You'll have, confusing applicants on this side, a little bit more relaxed applicants on the MMFLA side. That just doesn't really match up. And so again, I will use the word sabotage. And again, I'm not sure the real reasons for doing this during this term, but it certainly feels that way. And I'm sure a lot of voters who voted yes for that particular law with that language, with those amount of plants, with those micro businesses, certainly do feel potentially sabotaged by their elected officials for even proposing such a law that would completely gut the system that they voted for. And we haven't even gotten into the worst parts of it yet. So if you don't think micro businesses is bad, if you don't think home grow being gone is bad, one of the things that was certainly important to me was the social justice aspect in Prop 1 that it forced Laura to create a plan to remedy the effects of disproportionate social justice wrongs that were happening to certain portions of the community and the residents throughout Michigan as well as the United States. That is completely gone. So not only is the legislature attempting to remove your ability to grow plants, your ability to have some skin in the game as a local business owner, your ability to go through an application process very easily without, with the least amount of effort and pain. Now they also want to take away something that I think a lot of people agree with, disproportionately happened to a lot of individuals that wrongfully affected them. And apparently the legislature didn't think it important enough to be able to put that and keep that in there. So that's another thing that's very troubling to myself, as well as us all here at CLG. We really, are very confused about why, a lot of this is occurring right now.
Absolutely.
And then the last thing, there was a big discussion about marijuana is going to fix the road. It's going to fix the schools. It won't if the proposed changes happen. So what it actually does is significantly changes the amount that the tax revenue from this system is going to be allocated towards. If you want to kind of go over those numbers.
Right. So under the original version, or I'll just call it the Prop 1 version, the taxes that they were going to be getting from marijuana sales was going to go 15% to the municipalities and 15% to counties. And then 35% was going to go to the school aid fund for kindergarten through 12th grade. And then the remaining 35% was going to go to the roads. So 70% of the tax revenue was going to go between the kids and the roads. And the people of Michigan loved that. That's what we campaigned on. That is what we need in this state. We need to fix our infrastructure and we need to support our children. And now, under the new Senate bill, we have some new numbers. We have 25% to the municipalities, 30% to the counties, 5% to the county sheriffs, 30% to the state, 5% to law enforcement training, and 5% to the Michigan State Police. So that 70% that was going to go to the children and to the roads has been reallocated to various municipal and state law enforcement and administrative governing bodies. And I am absolutely in shock and really disappointed.
I mean, think of the children, right? I mean, no, in all honesty though, to be fair, as we discussed, this seemed like a very artful copy and paste job from the old MMFLA with no improvements into what the adult use law is. So a lot of these numbers are based off of what the numbers were like in the MMFLA. But again, I feel like it is subverting the will of the people to even introduce such a change, let alone have it enacted into law after a ballot. You know, you go through all those signatures, people come out and vote for it, it gets enacted, and then it gets just kind of ripped away. The legislature had the opportunity, once the Board of Canvassers certified the number of signatures to be placed on the ballot, they had the opportunity, I think back in September or so, to potentially change the law before the people voted. If they were to introduce such a thing back then, I think people would have still been skeptical, but I think people might have thought it made a little bit more sense that they wanted to, oh yeah, of course they have the power to, it's well within their rights to do this under the Michigan Constitution. But to do it this way, sit on their hands, let the people vote for it, and then try to gut it, you know, in a lame duck session, knowing that they only have a limited amount of time to do it, it just seems wrong to me.
Absolutely.
So I guess the question is, what do we do? If you're concerned about them changing this law that was voted by you, the people, what kind of options are there for people to kind of stand up against this potential law or potential proposed law becoming an actual law?
This law was implemented by the people, and it's going to be saved by the people. If you want to have a proactive impact on this, then you need to immediately call your senator, call your representatives, call some of the other representatives if you know them. Get on the phone, talk to them, have a dialogue with them, send them an email, go to a town hall if they're having a town hall. Ask to sit down and just chat with them about this and explain how important their vote is. And I think that's going to be one of the biggest and most effective ways to get this bill stopped as quickly as possible.
And I think the last I had saw, this bill was introduced by a representative senator. It was referred to the Governmental Operations Committee, so I believe they held testimony and they were able to take public comment potentially on a lot of these issues. I'm not sure that a lot of these governmental committee meetings are typically well attended, but certainly if people were forwarded to the right place in the right time on the right day, and that they received a lot of strong feedback against doing this, I think they would be put between a rock and a hard place between not listening to their constituents versus, you know, potentially facing those ramifications later on. You know, and I guess we're talking about the people who are still in office after this January, because potentially this says the backing of people who are no longer going to be in those positions come January. So what we can do is definitely make sure that we share any information with you regarding any hearings that might be able to be attended by the public for public comment. Be certain to call your senator within your jurisdiction that covers your area of where you live. And honestly, anybody else working within that area of government too, and also at the House, because the House is, if it passes the Senate, then the House is going to have to also pass it. So make sure that your government officials know exactly how you feel about this. If you're strongly opposed to any changes, we'll certainly be able to keep you up to date on that as we continue to follow this very closely.
Absolutely. So it's been a busy week. I am sorry that we have to end on such a serious and depressing note. Hopefully we'll have better news next week, but we'll definitely keep you updated in the meantime. And feel free to comment or like, share, and follow us on Instagram as well. Sound good?
Have a good day, everyone.
Bye.